The topic is protection of the rights of the people with disabilities in Sri Lanka, need for new legislation. Mr. DSR Jayawardena, who is having this qualification that of course he is an academic attached to the Department of Public and International Law, Faculty of Law, University of Colombo, who obtained a first class for his LLB degree at University of Colombo. I call upon Mr. DSR Jayawardena to deliver his speech on this topic.
Good morning, dear ladies and gentlemen. After some interesting presentation in this pleasant morning, could you please let me to take your attention into different dimension in the human rights aspect. So today I would like to speak upon the protection of the rights of the peoples with disabilities in Sri Lanka, and I'd like to raise some question. It is there any necessity of new legislation to protect the rights of the peoples with disabilities? So I will conduct my presentation in under following subtopics, especially description of the research problem, objective, literature, rationale of the research, literature review, so on. So when I move into my research problem, I would like to mainly discuss whether there is a necessity of new legislation and what is the availability and what is the capacity of existing legal framework, is existing disability rights protection legal framework. Therefore, I would like to discuss the pros and cons of the existing disability rights legal frameworks and hope to submit necessary recommendation for its further development. So here my rationale is I mainly critically analyze existing Sri Lankan legal framework with other jurisdiction and international legal instruments. So I did a literature survey. So I found that number of authors have written number of multiple scholarly articles regarding this topic. Especially Rutherglen, Cullen and Rutherglen observes that few decades ago people considered the concept of disability as a paranatural phenomenon. What is the paranatural phenomenon? Means most of the people understood, or most of the people thought that disability and the peoples, those who are suffering with disability, are different kind of community or different community. They have different expectations, they have different ideas, and their thinking pattern is different, something like that. But all of we know Now under the I would like to take your attention into modern concept, current concept. Current concept is apart from the disability, now people use the term called differently able. Why you use the term differently able? Because although they have physical capability or mental capability, incapability, they are capable in some other manner. For an example, it is usual, right? For an example, in general society, right? In normal circumstances, actually medical doctors are very capable in doing operation and giving medical treatments. But they are sometimes incapable in repairing their own vehicles. Lawyers are capable in practicing as a legal professionals, but they are incapable as a musicians. So, if someone has visual impairment, they are incapable in seeing something or reading something through their eyes, but they are capable to read them using assistive technologies. That's the thing. So, now the latest concept is differently able. So, I would like to pay your attention into our golden milestone of the international human rights arena. All of we know, all of we consider UDHR, Universal Declaration of Human Rights, as a golden milestone of the international human rights arena. So, what does it express? Article 2, it means equality clause, expressly said that no one can be discriminated or unequally treated on the basis of their race, color, sex, language, religion, or their political opinion. It means there's a doubt whether these conventions, whether the declaration impliedly allowed to discriminate someone based on their disability. That's the problem. But unfortunately, Michael Stein also observes that after the adoption of UDHR, key human rights treaties, UN key human rights treaties, 7 key human rights treaties are there. Basically, CRC Convention, CEDAW Convention, and 1984 Convention Against Torture, and ICCPR, ICESCR, all these conventions and covenants adopted similar clause as their equality clause. It means under those legal regimes also accepted the maltreatment to the person based on their disability. So my dear ladies and gentlemen, please let me to keep down the topic and move towards the research methodology of this research. I did this research in quantitative and qualitative research methods. Quantitatively, I went to 25 people with those who are suffering with disabilities and collected their ideas. And I went to disability rights scholars and academics, those who are interested in disability rights, and collected their ideas in qualitative manner. At the same time, for the accuracy of the information and to collect latest legal development, I did a library research and specially went through the internet articles and journal articles. So, according to latest research, right, there are over 660 million people, or more than 10% of the global population are suffering with some form of disability. So, although such a vast majority suffering with disability, and persons with disabilities are considered as the largest minority in the world, but until 1983 there was no specific attention for this group of people. So in 1983 UN has commenced their decade on the persons with disability, and in year 1983 to 1992 they have passed several resolutions for the well-being of the peoples, those who are suffering with physical and mental disabilities. At the same time, most importantly, they have appointed fact-finding commission under the leadership of Leandro Despuy. With this fact-finding commission, they have found that all parts of the world, people with disabilities are suffering with major maltreatments regarding to their occupation, education, and especially health and medical treatment and reasonable accommodation. After UN decade, in 1999, countries relating to North America have formed Inter-American Convention of the elimination of the all forms of discrimination against persons with disabilities. This is a first intergovernmental instrument, and all the governments have agreed upon to prevent all the maltreatments done by government and private entities for the persons with disabilities. In 2003, European Parliament has passed their resolution 1592 and specifically identified key human rights necessary to be protected for the persons with disabilities. What are the basic human rights? Actually, they identified right to education, right to labor, and right to private and family life as a key human rights. So, my dear ladies and gentlemen, I know now you have some problem. Why? Are they basic human rights for persons with disabilities? Or shouldn't there any rights to be prioritized? Actually, yes. Because I would like to raise your attention up to first bullet point of this slide. It shows there is over 60 billion people those who are suffering with disabilities globally. And I would like to raise another important point, that is, apart from these 60 million, 40 million people those who are living developing countries. It means Asia, Africa and Latin America. So, apart from the right to labor, apart from the right to education, right to private and family life, people those who are living in developing countries need to be fulfill their right to health, right to medical treatment, and especially right to food. So, when we quickly going through aforementioned conventions, we can observe those conventions are specified for the persons those who are living in specific area. So again, there is a necessity of global convention to globally address the disability right concept. On this purpose, in 2006, UN has formed UNCRPD, UN Convention for the Rights of the Persons with Disabilities. In this convention, right to accessibility and right to prevention from exploitation and right to personal mobility, right to habilitation and rehabilitation are understood as key human rights necessary for the persons with disabilities, specific for the persons with disabilities. Why those rights are specific? Please let me to give a small description about this thing. Right to accessibility. Although there is enough amount of facilities, although don't you have enough accessibility methods, you can't enjoy those things. For an example, although there is a hospitalities and medical treatments, if you don't have ramps, then wheelchair users cannot reach those treatments. And if you have enough amount of information, don't you have enough amount of accessibility softwares and all these facilities, you can't, if you are visually impaired, you can't use those information. Right? Here also, why I doing my presentation with my slides, because your staff allowed me to use my personal computer. That's the thing. So, like that, there should be necessary facilities for accessibility. At the same time, prevention from exploitation, especially girls and ladies, those who are suffering with mental disabilities, especially in developing countries, have been, most of the instances, they have been sexually exploited. And some instances, And most of the instances, countries like India and Sri Lanka, people who are suffering with disabilities are occupationally exploited, and sometimes they are exploited in some other ways. And mobility, right to mobility means the mobilization. They need some facilities to mobility. And habilitation and rehabilitation. What are the habilitation and rehabilitation? If you are suffering with disability, you need to interact with the society. So for the proper social interaction, you need specific attention and specific treatment and specific amount of training. So you need habilitation and rehabilitation. So in this context, I would like to raise your attention to the Sri Lankan context. In 1988, Administrative Circular number 3 of 1988 allows government to offer 3% of each job category for persons who are suffering with disabilities. But all of we know this is limited to the circular only. So in 1996, government has formed the key legislation, right? Key legislation, Protection of the Rights of the Persons with Disability Act, to protect, promote and disseminate the rights of the persons with disabilities. Under this act, Disability Rights Council, National Disability Council has formed as a main body. Under section 12 of this act, council has power to take any actions regarding the protection, promotion and dissemination of the rights of the persons with disabilities. And under section 13, they have power to submit their recommendation to any government entity towards said purpose. However, there is a problem whether the government entities are bound to follow all these recommendations. At the same time, in 2003, government formed NPD, National Policy for the Disabilities. But all of we know there is a problem, because you can't judicially activate the policy documents. All of we know in Article 27 and 28 there are golden principles in Sri Lanka, but those cannot be implemented. And in 2006 there is a National Disability Rights Regulation again allowed allow government to make all the buildings accessible for the people with disability. But in that court case, Ajit Pera versus AG, again judiciary, Sri Lankan judiciary asked government to do this, conduct said progress under progressive manner. So I would like to come to a conclusion. My conclusion is most of the instances a few decades ago, people were considered concept of disability as a paranatural phenomenon, but now people understood that the disabled persons, those who are suffering with disabilities, are people like others, and those who have right to enjoy other human rights. However, in Sri Lanka there is a need for new legislation, and there is a necessity of forming independent body to protect the rights of disabled people. Thank you.